Hi, my name is Kurt Harris, and I'm an attorney here in the Las Vegas area. I've been practicing law in the area of estate planning for more than 25 years. Currently, I'm working in conjunction with Nevada Corporate Headquarters. Frequently, as part of my role with Nevada Corporate Headquarters, I have the opportunity to prepare Revocable Living Trusts for many of our clients. I wanted to share with you some of the main questions that we have when you've purchased a Revocable Living Trust and some of the questions that come up as to how you should fill out the questionnaire or what things I should be thinking about in the preparation of my trust. The first thing I always tell people is that think about who your heirs are, or heirs apparent. Think about who you want your estate to go to and how you'd like it to be administered. The first thing is to make that determination. There are many of us that have very unique situations or other circumstances that we want to think about when we think about how we want to leave our estate and who we'd like to leave that to. Some of those items that we want to think about is, do I have children who are of special needs? Do I have pets? Do I have other unique circumstances or situations with my heirs that need to be disclosed at the time of the preparation of the trust? These are all things that all of us should be thinking about as we approach that time to pass on our estate. The second question that we get very frequently, which is very much like the first, is how do you want those assets to be transferred? There are a variety of ways that you can choose and pick from to transfer those assets, and that deserves some thought. For instance, you may have one heir or beneficiary who's very savvy in financial aspects, and you may have another who's not. You want to think about how you'd like to distribute those funds or those assets to those individuals. If you have a specific item of property that you'd like to leave to one of your beneficiaries, then that needs to be so stated. If there's a classic car or some item of jewelry, that needs to be identified in your trust or in your pour-over will. And so those are thoughts to have. Additionally, we always recommend with minors that they not receive 100% of their inheritance on the date of your death. Should they be 18, that might be a lot of funds for a minor to inherit. So we always recommend for those types of distributions in those types of scenarios that a minor might receive, say, 25% of their inheritance when they turn 18 to maybe help them get to college, and maybe 25% after they graduate from college or at age 25, and maybe 50% when they reach the age of 30 or beyond. Those are ways of enabling you to control the distribution of that estate beyond your death. And so that can be very important for some of our heirs as we make those determinations. In addition to that, we frequently get questions about who will be my successor trustee. And in the name trustee, obviously it needs to be a trusted individual, someone that we can rely upon, someone that we know will effectuate our desires and will fulfill the terms of the contract or trust. And so you need to think about who I want to be the trustee. Oftentimes I get people that say, well, I'd like my parents to be the trustee. And in reality, that would be ideal. But in practice, most of us outlive our parents. And our parents as a choice of a successor trustee are not always the best election or selection in your particular case. You might want to think about somebody who's younger than you or somebody who's going to be around longer than you who can see to your needs after you pass away, see to your family's needs, and make sure those assets are passed on to the next generation or to your beneficiaries as you have outlined in your trust. That's very important, and so you need to give that quite a bit of thought. And sometimes you may want to ask that trustee. I have many people that don't even ask and figure that it'll come up later, but that's something that you might want to think about. Finally, I get a lot of questions about what property should go into my trust, or how should I put it into my trust? There are various ways to transfer property into trust. We 100% recommend your personal residence be placed in your Revocable Living Trust. We think that is best at all times and in all cases. There are certain exceptions, but for the most part, putting your home into your trust is one of the best things you can do. In addition to that, you can place other properties into the trust if you want, or you can potentially not place them in and not worry about that. How is it that you are able to do that? And that's by the use of a pour-over will. If you have a pour-over will, the pour-over will is a catch-all agreement that ensures that any of your assets on the date of your death are transferred directly into your trust by operation of the contract or agreement. And so, if there are items of property that I did not put into my trust during my lifetime, my pour-over will automatically leave them to my trust after I pass away. So you have the pour-over will out there that will capture or catch any and all assets that are left behind, should you not do that or choose not to, or should it just be forgotten. So you'll be covered that way. In addition to any revocable living trust or pour-over will, financial powers of attorney and powers of attorney for healthcare are also critical to any estate plan. And we recommend those very much. They are frequently misunderstood though. We want to let you know that powers of attorney are revoked upon your death. They do not have any efficacy after you pass away. And while you are lucid or coherent, they also do not have any efficacy unless you specifically indicate that. So powers of attorney are revoked upon death or during your lifetime while you are competent. They are only invoked during incompetency, and so they really only have a limited time when they might be of use. But choosing the right agent, like choosing the right trustee, is very important on those powers of attorney. And so we recommend that you think about who that person might be. Again, someone who would be available and someone who would be willing to make hard choices and hard decisions with regard to your medical treatment or to your finances should you become incapacitated or disabled. These are some of the questions that we receive generally from persons, and this might help you in the filling out of your questionnaire or in the preparation of a Revocable Living Trust to answer some of these questions to enable the proper drafting of your trust to effectuate your desires and your needs. Thank you for your time. On behalf of Nevada Corporate Headquarters, we look forward to talking to you in the future.